Go ahead.
I was just going to ask if you could explain the chain of command letter that was
Okay.
brought to the board on the agenda last week that you composed and recommended.
Okay. Yeah. So there's an issue about that. The issue you guys have is right now, by resolution, your manager is the day-to-day person for just about every administrative issue. Okay. You have no contingency plan. You have nothing for what happens if Deidre is driving to work and is in an accident. She has been delegated a lot of administrative control. So I was asked, is that a problem? And I said, yeah. I mean, you guys need a contingency plan to deal with this because you have nothing in place. Deidre handles she knows a lot of things. She has a lot of institutional knowledge that if you don't have someone able to handle that, you're going to have a major problem. Okay? So the issue we've got is your bylaws and the contract with the manager create a gap. And that gap is board meetings that are non-emergency basis can't be called unless they're 5-day notice. Okay, and the 718 lays out what constitutes an emergency. If in the scenario I lay out, if you have an emergency need to address the manager, the question is whether it meets the statutory definition of emergency. So when that question was brought to me, the issue was simply, well, to avoid there being this emergency, you can put a contingency plan in place so you don't have to call an emergency board meeting. That's, I also understand there was some question about the elements necessary before that contingency can be triggered. Just so everyone's clear, those were not in reference to a specific person. That was, to me, it needs to be clear because this board might change, your manager, Deidre might retire, whatever. Your contingency for when a manager can, when there's a chain of command deviation, it needs to be under very limited circumstances that would justify such a step, such a drastic step. Okay, so that was directed at. It's my job to plan for every contingency. So when would it be appropriate for there to be a revocation, to be a change in command? It better be bad, like incapacity, or you've got a manager up there smashing computers. Okay, that's about when it should happen.
So you would recommend the board reconsider that and make that happen?
I mean, I think you guys should have some kind of contingency. If you want to discuss what the terms of it are, that's fine. I mean, if the question is, should you have a contingency? Yes. Should you have that one? I'm open to, I'm fine with someone telling me they like something a better way. But, I mean, you should have a contingency of some kind.
Okay, additional?
Does the emergency person have the right
Additional?
to take
Go ahead.
action?
My next question is by the reaction of the audience at the last week's meeting, the manager's suspension reasoning. I think we should elaborate on that a little bit, as I believe some may have thought it was done in malice, and the reasoning why we did it the way we did it.
We want to get rid of them.
Okay, I'm not, what do you ask?
Why don't we congratulate, get rid of them?
I just want to make sure exactly what you want me to elaborate
As
on.
far as we had to suspend, based on what you recommended in order to proceed with our meeting, we have to post a 5-day notice for our bylaws. So in order to do that, the suspension of Deidre was in place as far as the audience, unit owners thought we had already fired her, for example. But there was a reasoning behind that so that we could bring it to the board and go for a vote.
Well, I just want to clarify. The issue that was raised was, what are you going to do if you're going to terminate someone? Because you don't want to give them notice of 5 days that we're going to be firing you in 5 days and have them still in the office. And the question was raised, can we suspend them? My thing is, suspension is not expressly allowable, but the president has a lot of intangible authority as what's called liaison for the manager. And the president has the most administrative day-to-day authority of any board member. So the issue was, what do we do in that situation?
And why did that happen?
So when you're talking about, I just want to be clear, when you're asking about my recommendation is if you're going to take that course of action, then I think you can have a colorable issue of suspension, which is why it's in what I created in terms of going forward. If the board needs to do that, that legal authority is now there and not ambiguous. Okay, but if you're asking vanilla why you would suspend someone before termination, I mean, that would be the issue is you don't know. You mean it's just never, from an HR standpoint, a good idea to tell someone, hey, I'm going to fire you in 5 days. That's just, I deal with a lot of litigation. I can tell you 99% of the time how that's going to go. But in terms of why, I mean, that's it. I mean, procedurally speaking, if you're going to do something, then yeah, that would be the only way to cover the association to avoid there being issues.
How can the president just make that decision by themselves to just suspend somebody without the rest of the board even knowing about it?
Do you want me to go ahead and...
True.
So that brings us to follow up here, that it is, well, that's how it works. It's kind of the...
Well, first of all, before I...
We don't want his answer.
Why can't we
I understand.
get rid of Rogers and Rogers?
Okay. Well, let me first, there was a second half of that question that I should have addressed, which is individual board members have no authority to terminate anyone, okay? Which is why suspension was even on the table, which was you can't terminate anyone. If there is a suspension, it would have to be with pay because no board member has individual authority to do anything to the manager. It has to be by board vote, okay? So I should have, that was part of the first question. When you're asking me how does the president have any authority to do that, that's kind of what the issue is your bylaws and your declarations give the president the most administrative day-to-day authority of any member of the board. Further, your contract with the manager is that the president is really the oversight person, the day-to-day administrative liaison is the term for the manager. To the extent we said, well, what can we do? That's me saying, if you're going to fire someone and you're going to put that on the agenda and you're asking how do we cover ourselves in terms of that lag period between deciding to terminate and an actual board action, suspension was based on, I mean, that's the way other corporations and local governments, when you have this gap period, that's what they do. Now, again, that's based on logical application of other areas of the law to what you have, but that's why it was part of the chain of command going forward. What I was talking about a minute ago about why we have this letter for chain of command is to clarify that issue going forward.
Okay, any follow-up from Ms. Rogers? You have additional questions? Nothing at this point. Maybe Mr. Rogers would be next.
Nothing at this time.
Nothing at Mr. Rogers. And
But I asked one question, it was about what he just said.
we're going to get back around to that. We will. I guarantee it. And Mr. Singer is last. Anything from Mr. Singer? Nothing. Nothing from Mr. Singer. We'll start again at the top. First, I'll get to some of these things that are in front of me. If there's no problem with that. Go ahead. Well, I get these in order.
The president never said.
I agree with 100% of what you said with regards to our president being the closest to an administrator and the duties that she had. So I had actually no problem with her exercising her authority and doing the suspension. I think the issue came about is how it came about. But I believe that she had the authority to do it. Which brought me to my question for you with regards to the necessity for that chain of command motion. As I said, I already believed that the president had the authority to do what she did. I didn't like the way they did it, but she certainly had the authority. So if she already has that authority, why the chain of command letter being necessary? It seemed to me and to a few other board members that that chain of command letter went even further, giving the president even more authority than she already had.
Okay, and that's a great question. So, and to answer it honestly is to cover the association as a whole, okay? Because as I'm sure some of the reaction I'm getting is your board members are going to change annually. You might have some bleed over, you might not. Your president is likely going to change annually. Again, you might have some cover, or you might not. The reason I came up with a formal chain of command was to be very, very explicit about when the president can and cannot invoke suspension, what that means going forward, and when, basically, that it's not open-ended. You can't suspend the manager and call the meeting in a week. If you notice, if it goes through, it's very explicit. Number one, I wanted to cover when it can happen. That, to me, as the association attorney, is the biggest one. Suspending the person that has been delegated all of this board authority is a big deal. So it should only happen in the circumstances, and again, if you guys want to change those circumstances, feel free. I make no judgment calls on stuff. I'm simply supplying procedure. The second, though, issue is it lays out what that authority is and how long it lasts, what the protocol is for directing the association back to regular operation. And that, to me, is what's... Well, first of all, I think there is ambiguity about the suspension, but the bigger ambiguity is what happens once that option is triggered. And that's what I was trying to cover, is going forward. There's a lot of issues in your documents that lead to more questions than answers. And that's what I was trying to resolve, is if we hit this button in the future, what happens? And that there's no question, that everyone can look at the same document and go, this is what we do, step by step. So that was the goal.
So this clump here are different wordings, and basically just says, how do we get rid of a board member?
Okay.
There's assorted versions here.
Okay.
That's what we want
That's-
to do.
And
Wait, I just want him going through those and picking and choosing and asking the questions for us.
so again,
Assuming the questions.
Just to be clear for
Yes,
everyone,
certainly.
so I want to address something. I'm not a board member. I'm an attorney. They run, I'm here as the employee of the association, so if they direct something, so like when people are asking me questions, that just so everyone's aware, I defer to what they give me reign to do.
But they gave
Okay.
us permission to ask you any questions.
so this group is basically about recalling a board member.
Okay. Okay. Recalling a board member is not ambiguous. It's governed by statute and by Florida Administrative Code. It's Chapter 718 and it's code.
Excuse me, I'm bordering on dementia. I forget what you say. Could you say number 1, number 2, number 3, 4, and 5 exactly the steps that we have to take to recall board members? So we can write them down?
I will try my darndest without the statute right in front of me.
Thank you.
I think they can read that. It's in the statute. We're not here to, I think, use association time
Hey, it's her
to,
question, let them answer.
since the association, if there is one, is going to be like the defendant in this.
We're paying,
That becomes an issue.
we're paying for a lot of it.
The
Can I say what you said yonder, wasn't true?
what part?
When they first got voted in.
But they
and
didn't
you
get
said
voted in.
everybody had a meeting together, who wanted to be president, who wanted to be vice president, and went down the line. That never happened. That never happened. Certain
Okay, let's
people-
move on with this. It did happen. We were all at the meeting.
Certain people said, so-and-so's gonna be president, so-and-so's gonna be vice president. Ask my husband. He was not asked. They told him who it was gonna be. Is that all right with you, Sam? Honest to God.
They was
Okay,
never
let's move
voted in.
forward. There was a meeting, there was a vote, there were minutes of that meeting. It happened. Go ahead about the board
It was
members.
a scam.
Do you want me to? I can briefly address it, very briefly. Okay. I was here at the election. There was a board meeting. There was a vote on the officers. If a board member did not want to vote a certain way, that was their prerogative. But the vote occurred. I mean, and once a vote occurs, if the board is sitting and a vote occurs and it gets the majority vote, that is the action of the association. And to be frank with you, if one of them were to sit here and we were to vote to do something and they were to scream and be very unhappy and etc., but there's still a majority, that is the action of the board, and that is a vote of the board. Now, if down the road you decide, I don't like what I did, the board can take a second vote. But for all intents and purposes, and I think that's important for me to address as the attorney from the legality standpoint, you had an election, the board sat, they took a vote. If you tell me board members are going to change their vote, that's not that's their business. But in terms of how people are appointed as officers, if it's noticed and they sit and they have the vote, it's done. So that moving forward, that's how that happens. It does not matter if it's 5-4 or 9-0. Once you have a majority, that is the action of the association. All right, so going back to the original question. Florida Statute 718.112 governs the recall of board members. There is a Florida Administrative Code under Chapter 133 of the Administrative Code. I don't have that with me. So that part, but recall, what you need, you have to have 10% of the unit owners minimum to initiate one. You then have to get a majority of all the voting interest. Basically, you have a miniature new election about whether to recall certain board members. It goes through in detail whether you can do it in writing, whether you or by vote. But the point is, you have to have a majority of all the unit owners that voted for a board member. That's the simple. It is not. I'll be blunt with you. It is not easy. Okay. Most of the recalls that you see in the DVPR opinions are either developer recall or small associations, because you have to get the majority of the voting interest together to do it. Whether, as I said, whether it's in writing or whether you actually have a vote. Most people do it by writing. You have a piece of paper saying, do you want to recall Jane Doe? And you have a bunch of blanks, and you go through the association records and list every unit, and they have a little blank after their name, and that unit owner has to sign, and you have to get that majority of people. There's some more depth to it than that. But that's basically it. It is time consuming, it's expensive, and once you do it, then you have to bring it back to the board whether to certify it or not. And if they don't certify it, that's when I'm no longer allowed to discuss it with you, because it becomes an issue of the unit owner seeking recall or suing the association. And that's what I believe Mr. Anselm was alluding to. Why I'm not going to go into the pros and cons and strategies of it. The minute unit owners file for recall, you sue the association. It's like what's called a derivative action. The majority of the board is the association. So if you're suing for recall, I prosecute it at the discretion of the majority of the board. But that's the way the statute works. It's not ambiguous. It's not a matter of opinion. That's how 718 is designed.
A follow-up to that is if it's done at a unit owner meeting, the association is not involved? The unit owners do all the calling, the meeting, and everything else?
If you can call a special meeting to do a recall, but you have to follow the same rules of any other special meeting. You have to get 10%.
Does the association do it, or do the unit owners doing the recall do everything? Because the way the statute seems to be written now, or 61D rather, it seems to be, it's all up to them. They send out notices, they do it all. Is that true?
That's my understanding of it. The issue would be if you do it, and that's why most people don't do it the unit owner meeting way, is because it's very, very difficult. You guys, again, as I've reiterated a few times, the likelihood of you getting a full-blown enough people to constitute a unit owner meeting for the purpose of recall is probably a pipe dream. You would probably want to do it by written agreement. You're not going to get 51%, but written agreement is a different matter. That's what I was describing a minute ago.